Welcome. This is We Act Radio, trying to broadcast live from historic Anacostia in Washington, D.C. We've had a little technical difficulty this noon. I don't quite understand what it was. And our guest and I both left the StreamYard studio, and we are attempting to get ourselves back on air. We had some kind of weird, repeating loop going on that was impossible to listen to. So I will go ahead and say that you are listening to a relatively new series of programs called Conversations Toward Repair. And this is a relatively new series that I developed just a couple of weeks ago. And it is meant to focus on ways that violence is embedded in our city, nation, and globe, but that we don't always notice, and also highlight ways that we can work toward building peace. And both last week's show and this week's show are in some ways an interruption of that, but they're also fitting into this general framework of trying to see where violence exists in order to begin addressing forms we are too used to ignoring or not seeing. And in this context, our criminal code serves to perpetuate violence in many ways, and the revisions attempt to address some of those forms of violence with better 21st century definitions of crimes and more equitable sentencing. And the pushback against the revision also represents a form of violence in the use of fear-mongering and attempts to further divisions in and beyond the district. And here to help us to understand the revised Criminal Code Act is Patrice Sulton, Executive Director of the DC Justice Lab, and an attorney and professor and criminal justice advocate. She was also part of the DC Police Reform Commission, and maybe we'll talk about what has or hasn't happened since those reforms were recommended. And again, I am very sorry for our weird technical mishap. I have no idea what that was, but here we are. So, Patrice, anything else you'd like to add that I didn't include in your little bio there?
Maybe that you've been extremely helpful to the work that we're doing as part of DC Justice Lab, as someone who's been following these issues closely and in great detail and playing a role in terms of truth telling and solution development. So thank you for that, as well as this conversation today.
Well, I very much appreciate that. And I hope that you were able to hear the introduction in that, I am trying to make a series of programs that help us understand violence that we don't usually see. And I do think that this criminal code is one of those examples that for many of us, if I see those little, like, the S on top of the S that has like section symbol or whatever, it's like I feel intimidated, like I'll never understand it. So I'm not saying that's violence. I'm saying that is this system we live in is one that a lot of us just don't understand. So I thought maybe you could just start by telling us what is the revised Criminal Code Act, and maybe a little bit of explanation as to why it's been over 100 years since we had a revision.
Yeah, absolutely. So DC has never comprehensively revised its criminal laws. The laws that we inherited in 1901 are not of our own making, and a lot of other criminal laws have been added and amended since then. In the 60s and 70s, the American Law Institute created a model penal code for US states, and 29 states adopted some version of the model penal code that has a general part that says, here are the things that apply across the code: definitions, mental states, defenses, and then a special part that includes what are all of the offenses and what are all of the penalties? And DC never did that. So this is its first real opportunity to make a code that makes logical sense, that strips away things that are unconstitutional and are doing no good because they're unenforceable, to make the code consistent and to make the penalties proportionate, and to put in a classification system that rank orders things based on the severity of the conduct, the result, the circumstances, and the intent. And what's been so interesting to me over the last couple of months is that maybe because my voice has been so involved, it's been sort of mischaracterized as a decarceration effort or a racial justice effort. And that's actually not what the commission's mandate was. And the code that we got would look different if that was the lens through which we were working. This really was an effort to make a code that is sensible and fair, and it includes an awful lot of input from stakeholders on both sides of the aisle.
So that issue of decarceration, or trying to lessen the number of people who are incarcerated, is, of course, it's in the background, and racial justice is in the background. But if that wasn't the lens, then it's really more about making this more current. For example, I know that I learned that self-defense spray, like mace, has the same penalty as an assault weapon, because in 1901 they didn't know about probably either one. So can you address that, like, currency issue?
Yeah, it's interesting because we have these weapons offenses that are divided into possessing a weapon, carrying a weapon, having a weapon with intent to use it, and actually using it. And what's happened with the possessory offenses over time is that we've used them as a substitute for the more violent versions of gun offenses that involve actually using a weapon. And they're ill-defined. They don't take as much, they don't afford as much weight to the type of weapon that you own, like an assault rifle, a fully automatic machine gun, a bomb, as they do the identity of the person who possesses it, like if you have prior criminal history. And so the revised criminal code still includes a felon in possession statute, but it also raises the penalties for assault weapons and bombs in a way that doesn't exist under our current law. And it adds in a new offense for endangerment with a firearm that accounts for shooting behavior that is really hard to capture through just a possessory offense or through an assault offense that requires proving who the person was that you were trying to hit and getting that person to come forward and testify about it. And that's one of the more novel innovations in the revised code that I haven't heard talked about at all. And that would make DC a first to start looking at a new offense for gun violence specifically that's easier to prosecute than an assault or an attempted homicide.
So you're saying that the new revised version would not require the victim or someone who knows the victim to speak up about that? Is that what you're saying?
Well, we still have assault offenses, of course. We still have murder, attempted murder, assault, right? And all of those things are offenses against persons. And oftentimes when the government wants to prove an offense against a person, they need to identify who the person was, right? And maybe that victim doesn't need to come forward, but oftentimes you're looking for some kind of testimonial evidence saying, who was aggrieved, and you have this right to confront the person that's accusing you of that harm. And so when those cases are really hard, what we've done over the last couple of decades is to instead just put really, really hefty penalties on possession of a firearm. And so we say anyone who is found with a gun or who constructively possesses a gun, meaning we know it's theirs by other evidence, is facing really high maximum penalties and oftentimes really high minimum penalties. And it injects this fiction about dangerousness into possession alone, when we know that depending on the identity of the person, it might not really be accounting for the risk of harm associated with possession. It's really accounting for other kinds of social factors that are not giving us as much information about who should or should not have a firearm. I was reminded of this recently when we heard a lot of discussion about people on our police force who have engaged in domestic violence who were not terminated as a result of that domestic violence. And some people were suggesting that that is too harsh a punishment for an officer to lose their job. And what's interesting about that is we have so much research, so much information about the dangerousness of a person who is engaging in violence against an intimate partner having possession of a firearm. And if you or I were convicted of a domestic violence offense, we would lose our rights under the Second Amendment in any state in the United States. And so to think about a police officer still being able to not only have a firearm, but also be deputized to use that firearm in ways that others are not, is really frightening. And we need to rethink the way we talk about safety and dangerousness. And we need to rethink how we are deciding who can and cannot have a firearm and what the punishment is versus what are we doing to actually prevent harm.
And so, in your estimation, the revised criminal code does that better. Do you want to go into any more detail or just tell people where to look it up?
I would encourage people to read revisedcode.org, and a lot of our Twitter page has been trying to combat some misinformation about the code because it does reorganize and relabel things. So people who are somewhat familiar with current district law are naturally looking at the code and looking for offenses that we already have. And if you don't see it there, you might think that means it was decriminalized, and that oftentimes is not the case. And I've seen that happen a few times. So we're trying to make sure that that's really clear. But the other thing that's happening is we might give an example like there are 3 different versions of threats under current district law. There's one that says if you threaten to hurt somebody, that's punishable by 180 days. There's one that says if you threaten to hurt somebody, that's punishable by 6 months. And there's one that says if you threaten to hurt somebody or if you threaten to hurt someone's property, that's punishable by 20 years. And so when we create a new criminal threats offense that says these are the different gradations of threats, one of the criticisms that we might get from that is you've lowered the penalty for threats. You're taking threats less seriously, when really it is this very careful right sizing of what the penalties are. And it's taking into account all of the other things that are being punished under the code so that we don't end up with absurd results like somebody who threatens to destroy someone's property facing 20 years and someone who actually destroys someone's property facing only 180 days in jail. So that sort of characterization of things as lowering penalties has been something really hard to respond to in nice sound bites online. And so I hope that that explanation gives a little bit more context to what was actually done as part of the process.
Thank you. That was clearer to me. There's also some other things that, I confess I really didn't understand before that sounded clearer in that explanation, in that, the whole idea that you can, based on someone's identity, decide to charge them with a hefty penalty for being intimidating is a thing that I think our society has not yet really learned how to address very well. And I know you said that the mandate of the commission that developed this was not to put in place racial equity, but any law that can be used as a weapon against a Black person who's just minding their own business but looks threatening, that is going to have to be part of our. I hope it's going to be part of the result, going forward. And this might sound like kind of a jump to a new topic, but I was also thinking about I've lived in DC a very long time, but I was a teenager in the state of Illinois. And when I was growing up, it was statutory rape for a person who was an adult to be alone with a girl who was under 18. And so in some ways that was a kind of protection. If a predator was coming near you, you were taught to say 16 will get you 20, and hopefully they would understand that and back off. But it was also used to harass interracial couples, teenagers. It was also used to harass people who were driving, because if there was a younger girl in the car, they could just pull the car over if they felt like it. And parents could use it if they didn't happen to like the suitor, who was maybe 18 while the girl was 17. And that it had both a protection aspect and an aspect that really was wielded in ways that, in my experience, and that wasn't even DC, were very troubling. And I know there has been a lot of pushback about the sexual crimes, or the statutory rape in specific. There's been a lot of pushback on that. So can you explain what was the law and what is being changed with that?
Yes. So there are very few places in criminal law where strict liability applies, meaning there's no culpable mental state required in order to prove an element of the offense. You don't have to prove the person knew something. You don't have to prove the person intended something. You don't have to prove they acted on purpose. You don't have to prove they were reckless or negligent. They are just strictly liable if the facts are the facts. And statutory rape is one of those examples where the law says it doesn't matter if you knew the person's age or not, you're strictly liable with respect to the age of the person that you had an encounter with. And the original version of this bill decided to keep the line there and to say the person is going to remain strictly liable based on the age of the victim in the case. But there will then be an affirmative defense for people to be able to say what their mental state was and the reasonableness of their conduct in really narrow circumstances. And those are circumstances in which the person was affirmatively misled about the age of the person they engaged in consensual sex with, and that age gap was not very broad, and the person's belief was objectively reasonable, not subjectively reasonable, meaning I thought they looked older, right? And between the original version of the bill and the committee print, the concern that was raised was really about protection of girls of color, and a worry that girls of color are adultified, and that what would happen is that people would rely on this mistake of age defense to say, well, look at her, she looks older, and I assumed she was older. And that's really not how the defense was intended to operate. And we don't have evidence that that's how the defense has been operating in the states that have it. And so that affirmative defense was stripped out of the law, and there was nothing done on the other side to adjust for that mental state being strict liability, right? Because that's the other way you could handle it. You could say the person has to be at least negligent as to their age, and that would account for those kinds of scenarios. But the original bill was narrower than that and said, we're going to keep strict liability. We're going to put the burden on the defendant to prove this very narrow defense. We're going to require that it be objectively reasonable and not just their own opinion. And I think that that was a revision that the committee should have kept, but it's no longer in the committee print.
And so is there a chance to make any amendment at this point? Maybe we should just talk about the process and the vote coming up.
There is a second vote that the council will hold in the coming weeks, as early as Tuesday of next week. A vote is expected. And there is an opportunity at that hearing for council members to offer amendments. And in some instances, we are urging that the amendments that the council consider really are things that revert back to the original bill. So it feels funny to call it an amendment when we say, hey, there should be an amendment introduced to eliminate all mandatory minimums instead of most mandatory minimums, because that's what the original bill was. That's what the version of the bill that was transmitted to the council, that was unanimously sent there by all of the advisory group, asked to do. And so this reinsertion that happened between the time of the original bill and the time the committee print was issued, and really only upon a few days' notice to the public, is the version that we have some concerns about, because the careful drafting that was done originally is well thought out, and it is also delicate. And when you meddle with the penalties and you meddle with the definitions without regard to the rest of what was done in this package, it really can throw things out of whack. So mandatory minimums are a good example. Another example is that the original bill afforded second look for people after 15 years, which is consistent with what is done for people under 25 in DC. It's consistent with recommendations from leading legal experts. And it's actually 5 years longer than what's been called for by the American Bar Association and federal legislators who introduced a bill in the Senate. And the committee print extends that waiting period to 20 years imprisonment before a person can have a second look. And I think that was also a mistake, that we should instead adopt the 15-year mark that the commission recommended. They also extended the time period for jury trials to be restored in misdemeanor cases. And that's a really important change in law. And we don't have any reason to believe that it should take until 2030 to implement this without completely disrupting our court system. I think that's a myth. And an amendment could be introduced to restore jury trial rights. And then if I could offer two more as I'm going on and on, there were adjustments made to maximum penalties for certain offenses that DC punishes much, much, much more harshly than other states. And again, that's sort of an outgrowth of people misunderstanding the definitions of the statutes and how they work together, and not an actual lowering of criminal liability. It's that conduct is being captured across multiple parts of the code. And so a burglary isn't accounting for every part of a home invasion, it's accounting for the burglary part of the home invasion under the revised code. And so those changes to penalties, I think, lead to the code being less proportionate than it was originally. And then lastly, there were some quality of life offenses added to the committee print, including the criminalization of urination and defecation in public, the criminalization of possession of an open container of alcohol, the criminalization of a person making, quote, unreasonably loud noise at night, which has no definition and no sort of minimum proof requirement. And so all of those things that were just sort of injected are not written as carefully as the rest of the code, and leave a lot of room for unnecessary police contact and have real consequences for people who claim to be falsely arrested and want to have an officer disciplined or want to seek redress in our civil courts. Any officer could just say, well, it was after 10 p.m. and the person was being unreasonably loud. And then there was a basis for the contact and the arrest that leaves the person without any claim.
So the items that you just listed are things that you think should either be put back in or weren't done quite right. And for those of us who do live or work or worship or otherwise care about the District of Columbia, what, if anything, can we do between now and Tuesday? Should we write to a particular council member, to our own council member, to the chair?
I think to your own council members. Interestingly, the chairman of the council said at the press conference about the bill that he, supported what all of these experts spent years and years and years drafting, and the committee instead made changes to it. And so I think reaching out to the person that represents you in your ward or the at-large members is one way of saying, hey, I think that what was recommended by the Criminal Code Reform Commission that looked at this so closely, that studied the issue in an empirical and thoughtful way, really should be maintained, and that we shouldn't have a mandatory minimum in Washington, D.C.
So we're near the bottom of the hour, and I want to remind listeners that this is We Act Radio, broadcasting from historic Anacostia, Washington, D.C., even though we're still using virtual studios. And so my guest, Patrice Sulton, and myself, Virginia Spatz, are in different locations, but we're still broadcasting from the magic that happens at We Act Radio on Martin Luther King Avenue in Anacostia. So this is Conversations Toward Repair, and we're speaking with Patrice Sulton, who is Executive Director of DC Justice Lab, and very knowledgeable about the whole process of what DC is going through right now, revising its criminal code for the whole thing for the first time in 121 years. It was 1901, I understand. And can you give us a little history? Every once in a while, if I am trying to investigate something that happened even 50 years ago, I go back and I look at some of the congressional records and the way DC was talked about even 50 years, let alone 100 years ago. Can you just give us a little context for the 1901 code?
The 1901 code is interesting and broad, and includes, things that you may have heard that sound really silly, like common scolds and playing games in streets, and just sort of incorporates by reference Maryland's law, if there is any place that our law is silent. But between 1901 and the 70s, there's an awful lot of law that was passed by Congress, and I had an opportunity to dig into some of that legislative history. So, for example, when looking at the district's rioting statute, you can go back to 1968 and hear segregationists talking about the intent with which that law was drafted, and go back further and see some of the same language in the slave codes and the black codes in Washington, D.C. And that was a really tough statute to rewrite. And again, as an example of something that was completely removed from the committee print after the commission had spent so much time on it. But, we will never really have the same kind of local control over our criminal laws and penalties as other states until we have statehood. But this would be a huge step for DC to be able to say we actually have self-governance, we've exercised it in a really meaningful way, and to set an example for other states, both in terms of what statutes they include in their criminal code and in terms of how DC went about it so thoughtfully, including the input of stakeholders at every single stage in thinking about what the offenses should be.
And that process, can you just tell us a little bit more? Because a lot of us don't really keep on top of all this.
Sure. So the commission itself sounds like a big body, but it was really 5 lawyers in a basement. And they had an advisory group that had 7 members, 5 of whom were voting members from the U.S. Attorney's Office, the Attorney General's Office, the Public Defender's Service, and area law schools. Every month, this group met and examined really, really detailed and dense, I would never call them boring, reports that listed proposed statutory language, an explanatory note that said how every single word on the page should be interpreted, a comparison to current district law section that says, here are things that are changes in law, here are things that are possible changes in law, and here are things that are just clarifying the law because the existing statute is unclear, and a comparison to national trends section that said those things that are changes in law or possible changes in law are either supported by all of these other jurisdictions or they're novel and they're things that other jurisdictions should follow. It is incredibly detailed work. And for every comment received in those meetings and afterwards in writing, the commission then wrote a written response explaining whether those changes that were being requested from advisors were being incorporated or not being incorporated. And every single change to the code relates back to the mandate of the commission. And they made clear, we're making this change because it makes it more consistent, or we're not making this change because it would make it less proportionate, or we can't do that because it might be struck down as unconstitutional. And there's a justification for every single change or possible change in law. And that's why when you open the document with the transmittal letter, there are 4,700 pages of text attached, because that's how much this small team of lawyers did over the years to make sure they got it right. And it should be considered a living, breathing thing, right? There are new technologies over time. There are new shared values over time, and our criminal laws are subject to change. And we could never call any criminal code perfect, but this is pretty close to perfect if we want to compare it to what any other state has. And it's just something to really be proud of if it becomes law in the district.
And so I'm not going to read 4,700 pages. I think most of our listeners are not about to read that. Is it searchable if there's something in particular you just wanted to really delve into? Or how do you recommend that an average person who is freaked out by those little section things, look into it?
I think it is helpful to search for things that you might have trouble finding in the bill. So, for example, if you looked at the original bill and you said, hey, I really care about carjacking, I've been hearing about carjacking in the news, the first version didn't include an offense called carjacking because it just treated carjacking inside the robbery statute and referenced motor vehicles, which is what a lot of states do. And so if instead you went to that larger document and you searched for the term carjacking, you would find all of the justifications for any changes that were made to the district's carjacking statute in terms of how the offense is defined, how many grades or degrees of the offense we have, and what penalties are attached to each of those things. And you could do the same thing for any other offense that you're interested in, or for any of the defenses, right? We don't have a statute in current district law for self-defense at all. And so this is the first version of that. And so if you wanted to dig into how did they come up with how the self-defense statute reads, and what does that mean if I'm protecting my home, or what does that mean if there's a weapon involved, you'd be able to find all of the rationale, and you'd be able to find any objections that advisory group members raised and how the commission responded to those concerns.
So I always feel like I have to back up a step, because how can people get the whole document if they feel the need to search it or look for it?
Yeah, I'd be happy to give you the link because it's kind of long. Maybe I can make a short link that's more shareable, but it is online and it's attached to the letter that was used when the bill was transmitted to the council.
So if people were to go to the legislative information system on the DC Council site, they could find it. Maybe, I mean, I'd be happy to have a link if you have it, but we could also, is that right? We could tell people to look up the act on the Legislative Information Management System, LIMS, and they would find it. Is that correct?
Yes, that's
okay.
correct.
Okay. So there, as Patrice Sulton was just telling us, we can look up, you can go to DC Council, it's dccouncil.gov now. It used to be .us, both work, and look up the Legislative Information Management System, which will give you all the bills that have been introduced and their associated materials. I don't know how often there are 4,700 pages, but okay, I have a link here, and it is long, so I'm going to put it on the We Act Radio blog after our show, because I think if I put it up here now, it's just going to confuse people. I don't I don't have a good way. I guess I can drop it in the in Facebook or something. I'm not able to like do three things at the same time. So I will tell people who are listening that you can find it on weactradio.com. You can find it on Facebook. Later on, I will post it there. And also so that is the big 4,700 page thing that we were just given some examples about exploring it for ourselves. And then you mentioned that there are some Mythbuster items that have been shared by Twitter. If you have recently decided that you're not going to go on Twitter, there's been a lot of confusion on that. And there's also been people who just, have never been on Twitter. How else can they find that?
You could find that. We could add it to the revisedcode.org website so that it's a little bit easier to find. We have updated it a few times because it seems that each time we correct something, there is a new interesting non-fact being circulated. But the short link for it is if you type in bit.ly/RCCA, which is Revised Criminal Code Act -facts. That's the link to get to the Mythbusters sheet. And I'll share that with you as well so that we can share it out again online.
Okay, so the one that you're seeing right now, for those who are listening, it's http and then bit.ly another / revised code docs. That's the one that is a shortcut to get to the big, huge document. I'm going to take that off and we can put up the next one, which is the bit.ly RCCA-facts. And I am on Twitter, and I do see some of the things that are being shared, and I really recommend that if you are at all interested in the fate of the district, or as Patrice has been telling us, to see some of the interaction so that other jurisdictions might have some kind of model for what to do going forward, and also what not to do. You should check some of these things out. And as I think we found out in the election season that is not quite over, we spend a lot of time saying that if people just knew better, they would do better. But in a lot of ways, it's pretty clear that people don't need to know better in order to be on Twitter telling you some non-fact that they just decided would, for whatever reason. I mean, in some cases, they're really terrified that rape victims might not get their due. In some cases, they're just trying to halt progress, or they're trying to halt this act for reasons that might not be evident. So part of what this show is trying to do, this show that you're listening to right this minute, is to share out some resources so that anyone who cares, if you live, work, worship, eat dinner sometimes in the district, the laws here matter to you. If you live in the United States, the laws in the Capitol matter to you. So use some of these resources that have been shared and find out for yourself what's going on. And then maybe look at some of the things that people are putting out there and ask yourself why that is. And I, having made my little speech, I will throw it back to Patrice to say, anything else you want us to know about either the background of how it came to be. We've talked a little bit about the committee print and how it's different from what was presented by the commission. And maybe we could just take a minute to discuss that, because some of us take these things for granted, and some of us haven't any idea what a print would even mean in that, in that context. So can you just kind of give us a little picture of that?
Sure. So the bill was sent to the council in March of 2021. There were hearings on the bill last November and December, 3 in fact. And it wasn't until a few weeks ago, the day before the Committee on the Judiciary and Public Safety voted on the bill, that the committee's version of the bill was released. And the bill is hundreds of pages long. So 24 hours was not much time for anyone to be able to identify the changes and meaningfully weigh in on them. We had an advantage at DC Justice Lab because I knew the bill really well from my prior role at the DC Criminal Code Reform Commission, and we're able to jump in and say, these are the changes that we see, and these are the concerns that we have about them. And I think the difficult thing about us playing that role in trying to really share out information and engender a principled debate is that people make assumptions about what the intentions are behind the advocates who are speaking. And so I'm accustomed to there being this sort of layer of people mischaracterizing things as an effort to have leniency for leniency's sake without regard to public safety. And this just sort of fundamental misunderstanding that the work that we're trying to do is to reduce gun violence and other harm in our communities. And it's something that we'll have to talk about forever. It just is always going to be mischaracterized that way. But what was hard for me in seeing that happen with respect to the revised code is that this was not a DC Justice Lab measure. This was not Patrice Sulton's revised code. This was the code that was the result of years of working together with the stakeholders I mentioned, and a lot of compromise and thought was put into the text that's there. And everybody had things that they would have wanted to look different in the final output. And everybody said, this is the year that it needs to happen. It is urgent that the code be revised. And this is a great product for the council to sit down and consider. And so I don't want to give anyone the mistaken impression about the intent of any of the advocates who are arguing in favor of changes to the bill in any direction whatsoever. I think that where we disagree with the U.S. Attorney's Office for the District of Columbia is just a matter of disagreement and not a matter of either party wanting to make the district less safe or caring less about victims of crime or caring more about the people who are accused. And so I just hope there's a way to inject that into the debate more often, that everybody's fighting for what we think will be most effective at the end of the day. And, when you put sort of safety considerations and real risk factors and rationale and proportionality back into our criminal laws, a feature of that oftentimes is racial justice, and a feature of that oftentimes is decarceration. But that doesn't necessarily mean that everybody set out to do that without giving any thought or care to people who think differently. There was a lot of thought and care given to what everybody would most want to live under as their law. And we polled district voters with the help of HIT strategies and Forward earlier this year. And we're really excited to see the overwhelming support for doing a project like this and overwhelming voter support for the kinds of changes that were most controversial or seemingly most controversial, because really all the voters agreed, like mandatory minimums, second look, jury trials, eliminating life sentences. And I just am really hoping that people understand that this was a consensus building effort in ways that a lot of a lot of my personal work isn't.
Mm.
And so hopefully I can separate those identities a bit here.
Well, that is an interesting point, because it is also true that We Act Radio has a certain reputation, and that some people will discount maybe anything that comes out of We Act Radio for certain reasons, and maybe they will take it as gospel truth. Depending on, we all have to decide where we're going to get our news, where we're going to get our information, which advocates to trust. And the way our world has become, that just gets more ugly. The source gets attacked rather than the information. And I do really appreciate your coming and showing us, how we can look into it ourselves, and giving us a better picture of what actually is involved. So it doesn't look like, oh yes, we're revising the code because, well, we were just too tough on crime, or we're going to let people go because this is 2022, and that's what we have. This is the new fad or something. So the information is perhaps inaccessible to some people, but there are the fact checker that we shared. There's also the revised code website, which has a lot of information that you can look at. And it does occur to me that there are deeper, wider conversations that we also have to have. Like, is incarcerating people actually effective at making people in the city safer? There are discussions that we're just not really having, or that we're having them off in little pockets, but not as a city. And there isn't time, obviously, if this is all, it seems to me like it's happened pretty quickly, even though you've talked about years of process. As you said, the committee version came out one day before it was voted on, and then it was voted on by the full council. And now here we are, November 15th, which is just next Tuesday. It's going to be finalized, I guess. So I guess I want to ask how we can have some of the other conversations and also move the criminal code forward. It's very hard to separate.
I think those conversations will always have a place, because there is, a line drawing that's happening, and it's happening at the legislative level when we talk about what kind of punishment, what kind of violence by the state we authorize, right? What are the maximum penalties under the law? And oftentimes that gets conflated with what is the solution that's being implemented in an individual case. And people think about the facts of an individual case and what they think is deserved in that case when thinking about what the legislature should authorize for everyone. And that makes it really difficult to think about how to order things, and how to make sure that everyone has a voice in those individual cases. And one thing that I'm hoping to see more and more in Washington, that other states are doing a better job of than we are, is the inclusion of victims' voices in policy work. And we have a couple of organizations here who are doing an excellent job of both doing the legal services part of the work and weighing in on policy as an organization. But in terms of just an association or victim-led group where they are the members and it's composed of survivors of crime, I think we have work to do to make sure that we give those folks a voice to be able to say how important individual consideration is in every single case, not just because every case has different facts and every person who's accused is different, but because victims have their own expressed interests and they have their own best interests sometimes. Not everything is good for everyone. And we're doing a poor job of empowering victims in individual cases when we talk about things in a very general sense, the way that I see a lot of times from people who locally are really, really vocal on public safety consistently. So that's one thing I think would help the conversation, is to listen to more people who are thoughtful about how well tailored solutions to crime and punishment need to be, both at the prevention stage and after harm has been caused.
And so, in a related matter, there is also the Safe and Free DC agenda and the Police Reform Commission. We don't have that much time left, but do you want to say anything about that?
Please, yes. Thank you for bringing that up. Safeandfreedc.com outlines a really different kind of legislative agenda, and it was something we loved unveiling earlier this year at our safety summit with Harriet's Wildest Dreams and the National Reentry Network for Returning Citizens. And this, again, is an example of putting together an agenda that's not just about one group of people or one group of advocates. It's about harm reduction overall. And so if you want to follow along with all of the bills that have been introduced over the last 2 years that will be decided or dismissed in the next few weeks, that's a good place to keep track of those things that are on our radar that relate to policing, prosecution, punishment, victims' rights. And yeah, we hope that more people will sign on in support of the package that's there, but also just in support of the ideals that are set out in the introductory letter on that page.
And to go back to something you said earlier about the chair of the council deciding to support the work of the Revised Criminal Code Commission, that hasn't been so much the case with the Police Reform Commission, has it? Or, I mean, the recommendations have not been implemented, have they?
The Police Reform Commission recommendations didn't take the same form of a bill that is just introduced with everything in it. There are 90 recommendations there, some of which are legislative and some of which are things that the executive could do without a law being changed at all. And we have seen the introduction of a bill that Janice Lewis George worked with DC Justice Lab on that would curtail really dangerous chases in the city. We saw the introduction of a bill by Councilmember Robert White working with both Georgetown's Juvenile Justice Initiative and DC Justice Lab regarding the searches and interrogations of children in the district. And we saw Chairman Mendelson introduce a really big bill that incorporates a lot of the Police Reform Commission's recommendations about oversight and accountability of police officers. And those are all pending. And so is the bill that was first introduced in 2020 that doesn't have permanent force and effect. It's just an emergency or temporary measure that's been reintroduced. And so hopefully all of those things will move in short order after the revised code is voted upon. But again, it would be better to have a system in which there's a fuller public conversation when all of the changes to the legislation are happening. And so we're hoping that the next legislative session, people will be really thoughtful at the outset about how to foster that kind of discussion instead of rushing it at the end of 2024, the way that happened this year.
And so we are coming close to the top of the hour, and I apologize again for anyone who tried to tune in when we had trouble getting started, but we've had a very thorough conversation here. There's still things to learn, and Patrice Sulton, Executive Director of DC Justice Labs, has given us a lot of tools, which will be on weactradio.com and posted on other social media, so you can investigate for yourself and then make your wishes known to your own council member before the currently scheduled vote is next Tuesday, November the 15th. And if you're listening outside of DC, check out some of these resources just so you can see what is actually happening in the Capitol. And as Patrice told us earlier on, some of these things, if done right, could actually be a model for other places. And very often, unfortunately, I think DC ends up being a model for what not to do. The outside the Beltway looks at us and says, "Oh, look at that mess." And so this would be a chance for a different kind of a view. So with that, I will ask if you have any final remarks that you'd like to share before we close this out.
Oh, well, thank you for the opportunity to do a deeper dive into some of these issues. They are complex, and I just appreciate the attention that's been given to the bill and people's willingness to learn more about it in this format, and really appreciate your consistent interest in how do we make sure that people are kept safe from all harm. So thank you.
Well, I appreciate that. And for those who can hear it, we have been hearing a siren, which I think is outside of Patrice's location.
I'm sorry about that.
No, I just actually think it's instructive. It could just as easily have been happening outside my residence. It wasn't during this particular hour, but the sirens are very common, and they're very common on Martin Luther King Jr. Avenue, where even though we have soundproofing, you can hear the sirens if we're trying to broadcast from there. And that is a reminder that, we are not yet safe. We've got a lot of things to work on, and some people are more directly impacted by the lack of safety than others, and we've got a lot of work to do. So with that, I will have to say that we are coming to the end. You've been listening to We Act Radio, broadcasting from historic Anacostia, Washington, D.C. You've been listening to Patrice Sulton, who is founder and executive director of DC Justice Lab, and also independently expert on some of these legal things. And thank you so much for everything that you shared with us this morning. Till next time, peace.